Hi, I'm Neil Milton, and in this video I want to try to be clear about confusion. I know it's a goofy, terrible pun, but in trademark law that's probably about as good as it gets. You know, it's a fundamental rule of Canadian trademark law that two people cannot register trademarks which are confusingly similar to each other. In fact, if one person already has a registration, the rule bars a second person from registering a confusingly similar trademark. There are two parts to that test, and I want to go through each of them separately. Confusingly similar. In some respects, the similar is the easiest part to get your head around. It's similarity, not identity, that matters, or identical. So frequently people say to me, oh, well, Neil, we're the first ones. We've got it. There's nobody else has got this mark. And then you find out that there are many other marks which are similar, that a letter or two is changed. The test is similar when written or sounded in English or French. And if they sound similar, changing a letter or two doesn't get you off the hook. The second, or the part of the test, is confusion, and confusion has a number of features to it, but the crucial thing is, what is the likelihood of confusion in the mind of the ordinary consumer? So let's take that step by step. First of all, it's a likelihood of confusion. It's not a certainty of confusion, and it's likelihood on a balance of probabilities. This isn't some criminal standard, proof beyond reasonable doubt. The second applicant has the obligation to show on a balance of probabilities that it's not likely, there's no likelihood of confusion in the mind of the ordinary consumer. Now, the ordinary consumer is not a genius. The ordinary consumer doesn't have perfect recollection. The ordinary consumer is a person of average intellect and of average recollection, spending the time and attention to make the purchase that's reasonable in your industry. The average purchaser of nuclear power stations, to take a recent case, is quite a different consumer from the average consumer of rice at the grocery stores. But having regard to the ordinary consumer, what is the likelihood of confusion? So, you know, two identical marks, in fact, can coexist if they're on totally different products and there's no likelihood of confusion. So you sell chalk, I sell cheese, we can both call them Rooster brand. And it's unlikely, although in today's grocery stores you never know, that when you look into the cheese counter you won't find chalk. And so there's very unlikely that the ordinary consumer is going to face any confusion. They're actually not the same consumer, or even if it's the same person buying them, they buy them in different places at different times, and they're not going to then be confused about the origin of the chalk and the cheese. But let's take another example. Let's say you make shoes and I sell fishing lures. All right, I sell fishing lures, very, very good fishing lures, and you sell extraordinary, really great footwear. You would think no confusion. But what if your footwear is waterproof? What if it's mostly sold to fishermen? What if it appears in the same aisle at my local sporting goods store as my fishing lures? Now we're things are getting a little more difficult. Put it this way, I don't want someone phoning me up and saying, Milton, I'm not buying your fishing lures because the last time I bought those boots, they leaked. Hey, they're not my boots. That's the kind of confusion that trademark law is to protect against. It's to protect the source of origin, that when you see my great fishing lures, you know for sure they catch fish, and you're not confusing them and confusing the quality of my goods and services because of someone else's, the marks they've used on their goods or services. How is that? Clear as mud? No confusion about confusion? I hope that helps.